Hello everyone, I am Anupama Sharma, Assistant Professor at O.P. Jindal Global Law School. I am here to discuss with you second optional protocol to International Covenant on Civil and Political Rights aiming at the abolition of the death penalty. This is Module 4. This module will give an understanding of the purpose of optional protocol and its effect and applicability. Students, after studying this module, are expected to have an elementary understanding of the text of the optional protocol and its scope. This optional protocol was entered into force on the 11th July of 1991 with 60 state parties to it. Just as first optional protocol was focused on communications received by Human Rights Committee, this second optional protocol is focused on the abolition of death penalty as a means of punishment. It is believed that by abolishing death penalty, it will lead to a progression and growth in the development of human rights. By its essence, death penalty is considered to be grossly against the concept of human rights. Moreover, there have not been enough data to prove the effectiveness of death penalty as a form of punishment. In this light, this optional protocol upholds its importance and calls for abolition of death penalty by its state parties. Article 6 of the Covenant also enshrines the abolition of death penalty. We will now start with the discussion of Article 1 to 11 of this optional protocol. By virtue of Article 1 of this optional protocol, if any state party agrees to the provisions of this protocol, then it cannot execute anyone within its jurisdiction. Moreover, every state party will be obligated to take the measures required to abolish the death penalty if existing within their jurisdiction. Moving on to Article 2, it clearly mentions that it is not permissible for the state to have any sort of reservation to the protocol except for death penalty awarded in cases of war, and that too with respect to most serious crime. Such reservation can be made at the time of ratification or accession. Such a state party which makes such reservation will have to notify the Secretary General of the United Nations at the commencement and at the end of war concerning its territory. The state party is also expected to inform the committee of the measures it took to give effect to the provisions of this protocol. If under Article 41 of the Covenant, a state party has given the authority to the committee to receive the communications by other state party, then it will automatically extend to the provisions of this protocol. However, the state can absolve from this extended application by clarifying that no authority to be given to the committee for receiving communication with relation to this particular protocol at the very time of ratification or accession, whichever is adopted. Same applies in case the state party to the first optional protocol agrees to the authority of the committee to receive communications by individual. This shall extend to the present protocol unless and until specified to the contrary at the time of ratification or accession, whichever mode is adopted. Any state who is a party to the covenant can sign for this optional protocol as per Article 7 of the protocol. It is subject to ratification and is open to accession. Just as first optional protocol, this protocol also comes into effect from 3 months after the date of deposit of the documents relating to ratification or accession by state, and it shall apply to all parts without any limitation. The Secretary General of the United Nations is responsible to inform all the state parties about the signatures, ratification and reservations, if any. I am now going to refer to declarations, reservations and objections by the state parties while signing the second optional protocol. The information that I am now going to describe has been taken from the United Nations website and will help students to get an idea of the practical functioning. It is interesting to read the extracts as it provides the various reservations made by the state parties while agreeing to the provisions of second optional protocol to ICCPR, and also gives the objections raised by the other state parties to such reservations. We now start with the first such extract. We are referring to reservation given by Chile. The state of Chile formulates the reservation authorized under Article 2, paragraph 1 of the second optional protocol to the International Covenant of Civil and Political Rights, aiming at the abolition of the death penalty, and may in consequence apply the death penalty in time of war pursuant to a conviction for a most serious crime of a military nature committed during wartime. The next extract that I am going to read for you has been submitted by El Salvador and it's their reservation. The government of the Republic of El Salvador accedes to the second optional protocol to the International Covenant on Civil and Political Rights, aiming at the abolition of the death penalty with an express reservation permitted to states under Article 2 of the protocol, which consists on the application of the death penalty in accordance with Article 27 of the Constitution of the Republic of El Salvador, which reads as follows. The death penalty may be imposed only in the cases provided by the military laws during an international state of war. Objection to these reservations is now what I am going to read for your convenience. Austria's objection to this was, with regard to the reservation made by El Salvador upon accession, our views are as follows. The government of Austria has examined the reservation made by the Republic of El Salvador upon accession to the second optional protocol to the International Covenant on Civil and Political Rights, aiming at the abolition of the death penalty, adopted on 15th December 1989. The government of Austria recalls that it is the object and purpose of the second optional protocol to abolish the death penalty in all circumstances, and that no particular reservations are permitted other than reservations made within the limits of Article 2 of the Protocol. In the light of the wording of Article 2 Clause 1, a reservation to the Protocol is allowed to the extent that it concerns the application of the death penalty in times of war pursuant to a conviction for a most serious crime of a military nature committed during wartime. According to Article 2, Clause 2, the state party making such a reservation shall, at the time of ratification or accession, communicate to the Secretary General of the United Nations the relevant provisions of its national legislation which may be applicable during wartime. According to the information available, the applicable provisions of the national legislation of the country El Salvador in question, specifying the application of the death penalty to the most serious crimes of a military nature in wartime, were not communicated to the Secretary General as is required by the procedure. The government of Austria, therefore, objects to this reservation. This objection by the government of Austria shall not preclude the entry into force of the protocol between Austria and the Republic of El Salvador. The ratification of this protocol is extremely essential at the national level, as it prevents the execution in the confines of the state, and it is essential at the international level as it reaffirms the unified approach towards the abolition of death penalty, and that it is against the human rights and violates them adversely. With the study of the previous 3 modules and this module 4, we have realized the importance of human rights. Second optional protocol specifically talks about death penalty and how it should be abolished, since it is considered as the gross violation of human rights. Very few countries still continue with death penalty as one of their punishments, but have restricted it to only the commission of serious offences. The problem with administration of death penalty is it is irreversible in nature. Although the procedure takes care that there are enough precautions and there are procedural safeguards to ensure that no wrong judgment is passed with respect to death penalty, but if in case a wrong judgment is passed, it is rendered irreversible, thereby making the state liable for taking life of an innocent person. The other reason which justifies the abolition of death penalty is the theories of punishment under the criminal law. The various theories like deterrence theory, retribution theory, reformation theory have both the arguments for and against death penalty. However, it has not been proven that death penalty's administration has successfully deterred the criminals from commission of the offence. What is more important is the effective implementation of the criminal procedure and the fast remedy provided by the court, rather than the strictness of the punishment concerned. This optional protocol mandates the state parties to abolish death penalty in their respective areas. If they have any reservations, that has to be restricted to only few serious cases of wartime and has to be informed well in advance. We also went through the various reservations and objections to those reservations as put forward by the state parties. For your deeper understanding, I will now take you through other countries' objections to the reservation laid down by the country of El Salvador. France. With regard to the reservation made by El Salvador upon accession, the government of the French Republic has examined the reservation made by the government of the Republic of El Salvador upon accession to the second optional protocol to the International Covenant on Civil and Political Rights, aiming at the abolition of the death penalty. In that reservation, the government of the Republic of El Salvador states that it intends to make use of the right contained in Article 2, Paragraph 1 of the Protocol, providing for application of the death penalty in certain situations pursuant to Article 27 of the Constitution of El Salvador, according to which the death penalty may be imposed only in the cases provided by the military laws during an international state of war. Article 2, Paragraph 1 of the Protocol, however, requires that application of the death penalty be limited in times of war to cases in which either there is a conviction for a more serious crime of a military nature committed during wartime, the absence of a specific restriction on the reservation to the most serious crimes committed during wartime seems not to meet the requirements of Article 2, Paragraph 1 of the Protocol. In that regard, the reservation made by the government of the Republic of El Salvador is inadmissible pursuant to the very provisions of the Protocol. Thus, the government of the French Republic objects to the reservation made by the government of the Republic of El Salvador to the second optional protocol to the International Covenant on Civil and Political Rights, aiming at the abolition of the death penalty. This objection does not, however, preclude the entry into force of this protocol between France and El Salvador. The next objection that I am going to read for you is by Germany, which was laid down on 31st March 2015. With regard to the reservation made by El Salvador upon accession, the permanent mission of the Federal Republic of Germany to the United Nations presents its compliments to the treaty, section, and with reference to depository notification dated April 8, 2014 regarding the reservation made by the Republic of El Salvador upon its accession to the second optional protocol to the International Covenant on Civil and Political Rights, aiming at the abolition of the death penalty of 15 December 1989, has the honor to communicate the following. The government of the Federal Republic of Germany has carefully examined the reservation made by the Republic of El Salvador upon its accession to the second optional protocol to the International Covenant of Civil and Political Rights. It recalls that the complete abolition of the death penalty is the object and purpose of the second optional protocol, and that according to Article 2, reservations are not permissible with the one exception of a reservation that provides for the application of the death penalty in time of war pursuant to a conviction for a more serious crime of a military nature committed during wartime. The government of the Federal Republic of Germany believes that the reservation made by the Republic of El Salvador goes beyond the limits of Article 2 of the optional protocol, as it does not explicitly limit the application of the death penalty to the most serious crimes of a military nature. The government of the Federal Republic of Germany therefore considers that the reservation made by the Republic of El Salvador to be incompatible with the object and purpose of the second optional protocol, and that it consequently has to be considered impermissible. The government of the Federal Republic of Germany therefore objects to this reservation made by El Salvador. This objection shall not, however, preclude the entry into force of the second optional protocol to the International Covenant on Civil and Political Rights, aiming at the abolition of the death penalty of 15 December 1989 between the Federal Republic of Germany and the Republic of El Salvador. I hope with this students have gained enough exposure to the way observations, objections and reservations are placed by the state parties. Thank you for listening.